Good morning, ma'am. My name is Zangat Singh, and today I will be presenting a case law in front of you. The name of the case is LALMAN Shukla versus GAURI DUTT, and I will be starting with the intro first. LALMAN Shukla versus GAURI DUTT is one of the most famous landmark judgment case under the Indian Contract Act, and this case is about the validity of the contract if there exists no acceptance. It explains us about the essentials or requisites of a valid contract and Section 3 of the Contract Act 1872, which is about communication of the proposal. This case was filed in the Allahabad High Court in the year 1913 and was presided over by Justice Banerjee. Now I'll be starting with the facts of the case. In this case, the defendant, Gauri Datta, in this case, the defendant is Gauri Datta and the plaintiff is LALMAN Shukla. So the defendant's nephew departed from his home secretly and no one was able to find him. The defendant sent his servants to different places to search for his nephew. And the plaintiff, LALMAN Shukla, was one of his servants too. He had also gone to find the boy and bring him back. After LALMAN Shukla had left the house and was sent to Haridwar from Kanpur, he was provided with money and other expenses for his railway fare. As soon as LALMAN Shukla left the house, Gauri Dutt made an announcement that any person who will trace and find his missing nephew will be rewarded with rupees 501. LALMAN Shukla had no idea and was not aware of the fact, and he had no knowledge about it before he went to trace the missing boy. Then LALMAN Shukla traced the boy and brought him back to Kanpur. After knowing about the reward, LALMAN Shukla claimed the money from his master Gauri Dutt, but Gauri Dutt then denied paying the reward for rupees 501 to him, as a result of which the plaintiff LALMAN Shukla filed a case against Gauri Dutt, his master, for not giving him the reward as he was not entitled to recover for the performance of his act. Now, the arguments on behalf of the plaintiff, LALMAN Shukla. The plaintiff LALMAN Shukla strongly affirmed on his point that his performance on finding the missing boy himself is sufficient for him to be entitled to get the reward. He says, according to Gauri Dutt's condition, whosoever finds her nephew and bring him back, he will be rewarded as per the condition of the plaintiff. He traced the boy and brought him back, so he is entitled to the award declared. He stated that it is not important to have the prior knowledge under his circumstance about the reward which was associated with it. He also put the emphasis on the fact that Section 8 of the Indian Contract Act 1872, which states that the performance of the act or acceptance of any consideration of a proposal is an acceptance of a proposal. And here in this present case, the condition as stated by the defendant Gauri Dutt, and that whosoever finds the missing child will be rewarded rupees 501, and as per the plaintiff had performed the act, so he is claiming for his reward from the defendant Gauri Dutt. He stated it immaterial that it is not necessary that the person who has performed the act must have the knowledge about it. According to him, he has found the missing boy, so he has the right to get his reward. So these were the arguments made on behalf of the plaintiff. Now, the arguments made on behalf of the defendant, Gauri Datta. The defendant, Gauri Dutt, asserted and strongly stated her point by saying that first and foremost, the plaintiff LALMAN Shukla was not aware of the offer. He had no knowledge about it. So an offer without knowledge of the offeree or the promise cannot be accepted, and also there was no such possibility of the plaintiff to accept the offer without even knowing of the fact. Gauri Dutt stated the according to Section 2A of the Indian Contract Act 1872, When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtain the assent of that other to such act or abstinence, he is said to make a proposal. Further, in section B, he also stated that when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when acceptance, becomes a promise. Assent is very much essential to create a contract and accepting the offer, and the offeree must have complete knowledge of all the facts in order to give his assent or approval. But here in this case, the plaintiff was completely unaware of the reward which was associated with it. At the time of searching of the missing boy, the plaintiff LALMAN Shukla was merely doing his duty as a servant. He was working as a servant and it was his duty to trace and find the missing boy, and for the purpose he was sent to Haridwar from Kanpur. Haridwar to Kanpur, sorry. As there was no acceptance, there was no agreement which can be said as enforceable by the law according to section 2H. Without the knowledge of the offer before accepting a valid contract cannot be created between both the parties. So according to defendant GAURI, LALMAN Shukla was not entitled to get the reward and hence he could not claim it. So these were the arguments made from both the parties, the defendant and the plaintiff. Now, the ratio decidendi of this case. In the present case of LALMAN Shukla versus GAURI, it was derived that in order to enter into a contract, two critical aspects should be considered. You have complete knowledge of the facts of the offer or proposal, but and acceptance of the offer. A person to whom the offer is made, the offeree must accept the proposal. The communication regarding the offer is also very important, as mentioned in section 4 of the Indian Contract Act. It states that communication can only be complete when it comes to the knowledge of the person to whom it is made. As the plaintiff had no knowledge and hadn't given his approval or accepted the proposal, there did not exist a valid contract between the two. At the time of when the plaintiff was searching for the boy, his obligations and duties were as a servant. Therefore, the plaintiff LALMAN Shukla was not entitled to get any reward. Now the judgment in this particular case. In this said case, the petitioner's appeal against the respondent GAURI was dismissed by the court. After analyzing all the facts of the case, the Honorable High Court held that for creating or entering into a valid contract, there has to be a knowledge and an assent to the offeree made by the proposer. Here, the plaintiff did not know the reward before performing his act. He only came to know about it later, in which case there is no possibility of accepting the offer. Hence, there was no contract, therefore LALMAN Shukla was not entitled to get any reward. The judge said that plaintiff was fulfilling his obligation as a servant of tracing the missing boy, which was a part of his duty. Therefore, the plaintiff's suit against the defendant was completely dismissed by the court. So this was the judgment in this particular case. Now, there were some related cases which were given as an argument under the argument of the plaintiff and the defendant. So just a minute. Yeah. The petitioner was in the present. The petitioner in presenting his case had relied upon Gibbons versus Proctor, 1891, in English contract law. In this case, the court had held that if any person performs certain conditions of the contract, even if he is not aware of the reward or he does not have the knowledge of the reward, he is entitled to get the reward. So this was the argument, one of the argument made by the plaintiff, Lalman Shukla. Now, the respondent, on the other hand, relied on the famous US case Fetish versus Sendaker. In this case, Fetish, after giving the information about the murderer's identity, found out about the reward and then claimed it. The court in the said case had held the form of action in all such cases is an assumption. The defendant is proceeded against as upon his contract to pay, and the case and the question is, was there a contract between the parties? To the existence of the contract, there must be a mutual assent or in other form, offer and consent to other. Without that, there is no contract. How then can be a consent or an assent to that of which the party has never heard? The offer could only operate upon plaintiffs after they heard of it. Therefore, Patish was not entitled to the reward as he accepted the offer in ignorance, and person accepting the offer and offeree must have all the information regarding the reward before claiming for the reward associated with that action. In the end, the conclusion, the case between plaintiff Lalman Shukla and defendant GAURI DUTT examined the validity of the contract in the absence of prior acceptance. According to the judgment given by Allahabad High Court, a contract without acceptance is void. Therefore, despite his service, the plaintiff Lalman Shukla was not entitled to get the reward, as the mere performance of the act does not mean an assertion to the contract. Additionally, to turn an agreement into a proposal, it has to be enforceable by law. And lastly, the communication of proposal means that the person to whom the offer or the proposal is made must come to the knowledge of the acceptor before accepting the proposal. So this was the analysis of the case Lalman Shukla versus GAURI. Thank you, ma'am.